Okay, well, thank you all very much for joining us today. My name is attorney Wendy Guthro. I'm a practicing attorney here out of Burlington. I have my staff with me today. I'd like to introduce them to start with. Kathleen in the back. Yep, Jennifer here and Marie there. And we're available. We volunteer here at the Council on Aging once a month right now. We sometimes take the summers off. I think, Marie, we're here for the month of June, and then July and August off, and then back in September. We give free 30-minute consultations to kind of figure out if you have any issues with anything, really. I'm an estate planning, elder law, probate, estate administration attorney. But I try to reduce any barriers for especially Burlington seniors that have a legal issue that I might not be able to solve it for you, but I would at least like to help you be part of the solution and put you in a direction to get some help. Okay. So this is our second Lunch and Learn at the Burlington Council on Aging. Thank you very much, Marge McDonald and all of the staff here at the Council on Aging for allowing us this opportunity to bring this quote unquote public service announcement for you. Because what I believe with elder law and trusts and estates is that I really like my clients to know what we're talking about and why it's important to do this kind of planning. And so as an elder law attorney, it's extremely important for me to feel that, especially in the town that I live in and practice in, that my people are taken care of. So thank you all for coming today. Today's seminar will focus on protecting your assets from a nursing home in the event that you need to go into a nursing home facility or stay at home with in-home care. And so the acronym that you use for a nursing home is a SNF, an SNF, a skilled nursing facility. And if you need a skilled nursing facility, it means that your level of care has risen to a level that you normally can't be taken care of at home. So you'll hear the word SNF a lot, SNF. It's a skilled nursing facility, and it's really where most of us don't want to go. So what we try to do is have our best life and take care of ourselves as best as we can and stay as mobile and as sharp as possible so that we can take care of ourselves with the assistance of our self, our mate, our children, our friends, neighbors, and support staff. So I really like to say to my people, like, let's try to do what we can while we are able to keep ourselves as healthy as possible. But also, let's start to have a conversation about what happens if we are not able to care for ourselves, right? So you don't have to get all doom and gloom about this, right? We plan for everything in life. Let's start to put a plan together for what happens or if something happens to us. You've received a blue folder on your at your seat here that has some handouts in it. I'll be referencing many of those handouts today. We've also included a note-taking sheet and a pen on the inside of that. So if you wanted to take some notes as we're going along. I'll just quickly review what is in that. So this is your note-taking sheet. And by the way, we're recording this, and there's also some people on Zoom that are, or WebEx that are attending remotely. So I'll not only speak to you, I'll be speaking to the people at home as well. And then here's a pricing sheet that's involved in this included in this packet as well. And if anybody at home would like these specific documents, you can just email office@guthrolaw.com and all of this entire packet can be sent to you. And that's office@guthrolaw.com, and we'll get that off to you. And then a couple things that I'm not going to go into detail on all of these things today because it's a very robust topic. I'm going to try to keep my talk to about a half hour today. So the first sheet you'll see is the 2022 Basic Rules of Nursing Home Medicaid Eligibility in Massachusetts. This 3-page double-sided document really talks to you about how the Medicaid system works in Massachusetts in the event you need a nursing home and you would like the government to step in and pay for it. The next document you'll see is the 2022 Massachusetts Medicaid numbers, and on the reverse side of that is non-countable assets. These numbers I will be reviewing with you in a little bit of detail today, and as many of you may know, if you want to participate in a government program in any capacity, oftentimes you have to be income or asset eligible. And one of the top numbers on this sheet is the number 2,000. And that has been a constant number for a long time. That $2,000 figure are the assets that you are allowed to have in order to qualify for a nursing home and the government to step in and pick up your tab if you're an individual person. $2,000. And on the back of that same sheet are 5 other items that you are allowed to have in addition to the $2,000. So I'm just giving you a little bit of a roadmap of where we're going today so that you'll at least have a resource you can reflect on as I'm speaking. The next document, it should say home transfer strategies that do not cause a mass health penalty. And so these are some of the exceptions of when you can possibly have more than $2,000 to your name and still qualify for the government to pick up your nursing home bills. One of the last pages in the buff paper is frequently asked questions that might address some of the questions that you have. And then this document is on my website, which is www.guthrolaw.com, and it's reflected on almost every document here. But this is one of the pages of my website that is visited most throughout the United States. So it is the difference between a revocable and an irrevocable trust. And I included this in your packet because this is really where you have to start when you're going to start to talk about asset protection planning. Because the difference between a revocable trust, which is what many people have, is very different from an irrevocable trust, which is what we're going to be talking about today as an element for asset protection. So that's pretty much where we're going to start with to get us started. And we're going to have questions and answers at the end, so feel free to write down your questions. So, asset protection. We have 2 different entities that provide healthcare systems in Massachusetts. One is called Medicare, and you're probably all over the age of 65, and most of you would probably qualify for Medicare. And an easy way to remember Medicare from the other one is that it has the word care in the end of it. And it's the government cares about you. So they're providing you with health care under the Medicare system. Okay? Now the other system is Medicaid, with the word aid at the end of it. And the reason it has the word aid at the end of it is because you need the government to aid you because you don't have enough resources to provide you with what you need. So an old terminology is that it's a welfare-based program. So when we're doing asset protection, when you have Medicare and everyone's caring for you, and then you have Medicaid, that Medicaid in Massachusetts is referred to as Mass Health. And it has many different types of programs under this Mass Health Medicaid umbrella. And I'm going to be talking to you today about only two of those programs. One is called the long-term care program when you are in a nursing home and receiving care. The other is the home and community-based waiver program. It used to be called the Frail Elder Waiver Program, and that's what we still refer to it. You have in the room with you today two very important people to always help you figure all of this stuff out when I'm not here. And they are your outreach workers here at the Council on Aging. I rely on them as a resource. I hope that you do too. And everyone at home, if you need assistance and you are a Burlington senior, you should know that we have fabulous resources available to us here at the Council on Aging. Two of those people are here with us today. If you wouldn't mind standing up, Andrea Cross, Brenda Pappas. I can't tell you, these two people are fabulous, fabulous people with a skill set that can aid you in more ways than you can imagine. If you have a problem, you should really look to the resources at the Council on Aging. So we have Medicare. Everyone's caring about you. And then we have Medicaid, that you need financial help to pay for things. Aid, welfare-based program, now called Mass Health. We're going to talk about one of those programs a lot today, which is the long-term care program and the Frail Elder Waiver Program. So you have money, you have a house, you might have a deed to your house, bank accounts, CDs, stocks and bonds, mutual funds. You could have engagement rings, Patriot mug collections, furniture. These are all considered assets. So when we are going to be looking at protecting, we are protecting these things, right? And who are you protecting them from? When you're dealing with long-term care, many people think you are protecting them from a nursing home. But it's not really the nursing home. It's kind of taking your money. If you have money, you're privately paying. But it is the government that is going to ultimately be paying for your nursing home bill if you need to use the Medicaid Mass Health system to pay for it. So when we are looking at protecting our assets, you're protecting them from having to privately pay for your care in a skilled nursing facility or in the home environment. So what I want to tell you, if you can remember one thing from today, it is that if you don't want to privately pay for a nursing home or your at-home care, and the bill currently at most nursing homes in this area is about $14,000 to $15,000 per month for your nursing care. And there's value in that because you are asking other people to come and care for you, bring you your food, prepare for your food, take care of your linens, do everything that you are doing at home for yourself. Someone else has to come and do this. So for me, I think $15,000 is a lot of money. But when you think about what that $15,000 is buying you, there's a lot of value there. So the one thing I want you to remember is that if you don't want to pay for your own nursing care to the tune of $15,000 a month, you have to show Mass Health, Medicaid, the government, that you don't have the money to pay for it yourself. Because the way our society and government social programs are built, that when you're young, they help you accumulate money. When you start to get older, they want you to start to spend your resources on the things that you need. And then if you don't have any resources, then they will step in and aid you through these programs. But they would like you to use your personal resources to privately pay for your care in a home environment or in an institutional environment if you need it. If you don't have any money, or they do reward you if you do planning 5 years in advance from the day you need to go into a nursing home, and you're going to ask the government to pick up your tab. So that is the infamous 5-year look back program or 5-year look back period that they talk about. So you need to be able to divest yourself. And I'm going to continually use this word divest. Divest is that you do not have control over that asset. You don't control the money in your bank account. You don't control maybe your personal property, although it's not as important to protect this because this is one of the exceptions. You're allowed to have personal property and still qualify for a nursing home as long as your individual assets are $2,000 or less. So your bank account. So divesting yourself of a bank account would mean that your name and your social security number are not attached in any way, shape, or form to this bank account. The same thing with the CD or your stocks and mutual funds or your stocks and bonds at a brokerage house, Fidelity and Edward Jones, Charles Schwab, any of them, that you currently might have a retirement account, could have a regular stock and bond portfolio there. If your name and your social security number are on those accounts, you would have to get them off of those accounts to divest yourself of the asset and start the 5-year look back period. So there's a couple ways to divest yourself, right? We have, say, the house. And on this house, we need to get our name off of this house. So there's 2 primary ways of divesting that we're going to talk about today. One is gifting outright to your family, friends, neighbors, charities. The other is using an irrevocable trust for Medicaid planning. So I'm going to review the 2 different options and then tell you the similarities, and then I'm going to discuss the differences. So if we are going to gift our house to our children, we're going to come to Attorney Guthro or any attorney and say, Attorney Guthro, we would like to give our house to our children right now. I will draw up a new deed. So if I was doing it for myself, it would say Wendy Guthro individually transfers the deed to her home to her 2 children outright. I've given up my interest in the house now, and my house now belongs to my 2 children. Some people like to retain what they call the right to live in the house for the rest of their lives. Is anyone familiar with that? Life estate, some of you have a life estate maybe with a deed. So you are giving most of your house to your children, but you are retaining the present interest to live in your house. And if you're applying for Medicaid mass health in a nursing home, they just don't look at this house that you gave it to your children if you retained the right to live there. They put a value on your life estate. And the valuation process is explained in one of the handouts I gave you. And it is directly tied to the value of your house and your age. So that as you, maybe at the age of 50, if you gave your house to your children and it was worth $200,000, well, then your children have $100,000 interest, and you, as a life tenant, have retained $100,000 interest. Then when you're 60, maybe your children's interest has shifted up to 60%, and your interest has dropped down to 40%. And so the older you get, your interest goes further and further down until I think it's at age 100. They say you no longer have a present interest in your estate, in your home. So the reason that's important is because life estates have values, and mass health, Medicaid, can go after that value. They retain the right. When you enter into a nursing home, they ask you or your representative to sign a document that says, we are allowed to put a lien on your house for the value of your life estate. Now, Medicaid has always been able to do this. And in every state in the United States, they've always been able to do that. In Massachusetts, up until about 3 years ago, they could do it, but didn't do it. So as an elder law attorney, when clients came in and they said, you know what, I don't really want to go in the $3,000 or $4,000 range for one of these irrevocable trusts. How about if you just do a deed transfer for me and give the house to my kids and retain the right for me to live there for the rest of my life for less than $500? Very economical. But right now we see that Medicaid has decided they're going to start putting liens on the homes. So it was economical, but always with the condition that they could at any time decide to start liening your property. Okay? So it's all doom and gloom, right? This is all miserable stuff we're talking about, but we're trying to protect your assets. So that's where you have to understand the implications of each one of these transfers. And as I started at the very beginning, my Burlington people are important to me to get you educated, to understand what it is we're doing so that you can then decide, is it worth it for you? Do you want to spend the money? How much control do you want to retain or give up? My clients don't want to lose any control, but want the 5-year look back period to start. They don't want to divest themselves of their assets, but they don't want to spend $15,000 a month for nursing home care. You can't do it. You can't do it both, which is why I want you to focus on divesting yourself of your assets as part of your asset protection scheme. So the 2 ways. One is outright gifting, which is what I said about this deed, right? You outright gifted it. I gifted my house to my children, didn't retain a life estate. I gifted it outright. Now, if I had done this gifting to my children on May 23rd, 2017, Does anybody know what that is? 5 years ago. If I did this transfer 5 years ago, May 23rd, 2017, and today on May 24th, 2022, I needed a long-term care facility. I needed a skilled nursing facility. And I completed a Medicaid application for the government to pick up my dime. And they said to me, do you own a house? I check off the box, no. Have you transferred your house to anyone in the last 5 years for anything less than fair market value? I can check off the box, no. By doing that, I have protected this asset from being an asset that the nursing home could either be made whole from later on when I die and my bill needs to be paid, or that they need to be paid back, or the government needs to be paid back. So your goal is to protect these assets now and from a future lien being put on them. So you need to work with the 5-year look back period. So this is one option, gifting. So I have given this house to my children, and I did not retain a life estate. And the next thing I know, my grandkids and daughter are moving in with me. I'm like, whoa, what are you doing? This is my abode. And they're like, no, look at this. This is my house. When are you moving out? Am I moving out? No. I just did this to start my asset protection plan. Yeah, well, we have a different story. Like, we really need more space. We're in a little city house. Like, you can go live in our house if you want, but we're probably going to sell it in the next year or so. So I lost control. This gifting outright of assets only works if you have a really great family dynamics, no mental health issues, no addiction issues, right? No money hungry kids, no kids that are feeling like they've waited too long for their inheritance, So if you are going to outright gift, it is a great strategy to start the 5-year look back period. But you have to recognize you have no control. You have lost control of the asset. I deal with a lot of clients that this works fine, but there are other things that they don't take into consideration sometimes, which are, we call them in the business the outlaws, which are the in-laws. That daughter-in-law or son-in-law who is the other half of the child whose name you put on this, that now becomes part of their estate because your son's will said, upon my death, everything goes to my surviving spouse. Right? So that daughter-in-law is now co-owner with your other child, and you are even further out of this picture. Right? So this is gifting. It could be jewelry. It could be $1 million bank account. It could be a $25,000 bank account. It could be a CD. It could be a brokerage account that you got your name off of to start the 5-year look back period. So this gifting strategy is one of the two strategies we're talking about. It works for asset protection. But you need to figure out, does it work for you and your situation? Which is why there is not a one-size-fits-all solution for anything that you'll come to an attorney for. Because an attorney really sits down with you, and one of the first things we ask you to do is to complete a questionnaire. Tell us what your family structure looks like, what your asset structure looks like. Do you hold most of it in very accessible, we call this liquid, non-qualified money? Or do you hold it in retirement money? That's qualified money. That's a taxable event if you transfer it to start the 5-year look back period. If you have a $100,000 401k and you want to start the 5-year look back period on this, you need to pull it out, cash it out, and put it into your children's names. So what do you get at the end of the year? A 1099. Oh, look, in addition to your Social Security income, you have $100,000 added to your 1099. Now, you were in one tax bracket last year when you just had your Social Security, or maybe you didn't even have to pay taxes last year. But now when you have to pull out your retirement money to start the 5-year look back period, you now have gotten yourself into a higher tax bracket and are paying even more taxes. So this is the face of gifting. And again, it is a very good solution if you want to start the 5-year look back period in hopes of the government picking up your nursing home tab. So, yes, yeah, you can go ahead and ask a question.
Would that start the 5-year look back on all your assets or just on the house?
The question was for the people at home, would this start the 5-year look back period on all of the assets or just the one? It is just the one. So if I transferred my deed today, or if I transferred it back on May 23rd, 2017, it started the 5-year look back period for this. So for my one bank account at Bank of America, my other bank account at Citizens, at, wherever they are, each bank account, each asset has its own 5-year look back period, depending upon when you gifted it. Now, how would Mass Help know? Right? Well, first of all, you'll always run everything above board with Mass Help. They have ways of finding everything. So that's why we're doing this seminar, to give you the knowledge that you need to do your 5-year look back planning in advance. So if you have assets, the other thing I want to talk to you about is that having the government step in and pay your nursing home bill is also not for everyone. I've had many clients that have said, I have spent my whole life accumulating wealth, watching my pennies, saving, being frugal for this time in my life, so I can privately pay and be in the nursing facility that I want to be in, bring in private duty nursing into my home environment, go to an assisted living facility. They're in the $6,000 to $9,000 a month, privately pay for my care and assisted living facility. And then I'm going to use my money to take care of me. And you know what? Those kids that are waiting for that inheritance to come through, they're going to be waiting a little longer. Maybe there won't even be anything in the end. But I do encourage you all that you have put your time in. Don't hesitate to spend your money on you. Okay? So this is gifting outright, no trust, very simple. Don't even need an attorney unless you're going to maybe do a deed transfer, right? These are all things you can do on your own, homegrown solutions. So we're going to now transition to the other area, which involves an attorney. It's complex planning, but the thing that is great about this is that you retain some control. And that's what a lot of clients like about this type of irrevocable or irrevocable trust planning. For some of you that don't know what a trust is simply a container to hold things. So if you think about that, this whole thing about getting assets in and out of the container will make, or in and out of a trust, will make a lot of sense. So you see on this container, you can see through this. So that means to me that this is a revocable trust. And that if you put your deed to your house in this revocable trust, and you can see through it, you can see the house, it's yours. The government and the nursing home can see that it's yours. This offers zero, that is in no, nada, nothing, no asset protection plan. So if you have a revocable trust and you think that you've gotten your house, your assets into here, and that you're protected in the event of a nursing home, that is not the case. And I bring this up because 3/4 of my clients believe they've got a trust, so they're all set. So revocable trusts, see-through, any assets in them, available to the government and the nursing home to pay for your care. Even if you did it 5 years in advance. Doesn't matter. A see-through revocable trust is all assets in it are always available to pay for a nursing home. Now, we have a very different trust. You cannot see through this trust, can you? This is an irrevocable trust. And on the tables, there is this sheet because I want you to first understand the 3 positions when you have any trust. The first is the grantor. You are the grantors if you create this trust. So on my trust, irrevocable, I am donating, I am granting my real estate. What happened to our real estate? Well, we'll say that we're gonna. The kids took it, that's right. The daughter moved in, the kids are in there. So I transferred the deed to my house into this trust. I granted it or I donated it into the irrevocable trust. The trustee of a trust, that is the person that has to follow the rules written on the trust. So just to give you a sense, this is graphically what a trust looks like for our conversations. But this is what your irrevocable trust really looks like and your estate plan. But this is all what your document actually would look like. So we have this irrevocable trust. You donated your assets into it. The trustee has to follow all of the directions that are outlined in that binder. And the beneficiaries are the ones that benefit, get to enjoy the asset during their lifetime or upon your death. Now, in a regular trust, you're everything. You are in all 3 positions. You are the grantor. You are the trustee. You are the beneficiary. But it's very different with an asset protection trust because you have to limit your control. You have to divest yourself of the asset. You have to divest yourself of control. So we allow you to be the grantor because, of course, your children would love to have your house in the trust for later, right? You're donating your bank accounts, your CDs, your stock portfolios. So you're putting your assets into the trust. But we don't have you be in charge of following the rules on the trust because Mass Health doesn't like that. They say if you're in charge, you could maybe change things. Maybe you could find a way to get the money out. Maybe you would just have a weak moment and that $50,000 bank account that you gave to the kids the month you liked them, and now you don't like them and you want to go get that back. They think that you are going to find a way as trustee to go get that money back. As beneficiaries, what makes this trust very different from all other trusts is that the ownership as a beneficiary splits. If in a regular see-through revocable trust, this one, you own, in that $50,000 example, you own that $50,000. But and if that $50,000 makes $10 in interest this year, you own the $50,000 and you own the $10 of interest. But this trust is very different. We split that the interest and income you earn off of an asset you get to keep every year. But the principal, that $50,000 that you gave away to start the 5-year look-back period, that does not belong to you any longer. You have divested it successfully. So, on that $50,000, 5 years goes by, right? So we did this in 2017. Here we are, May 24th, 2022. You have just gotten through your 5-year look-back period on that $50,000. Now you need a nursing home. We fill out the application. Have you given away any money in the previous 5 years? No. Do you own a house? Nope. Gave that 5 years 1 day ago, right? You've transferred all your assets. They then have another part of the application that says, how much money do you bring into your household every month or every year? So when you do a Medicaid application, you do income and you do assets. This that we started talking about is all about the assets. The income is how much money you bring in from your retirement, Social Security, your investment portfolios, whatever the case may be. So I tell you about that because this is where the rubber meets the road on that $10 of interest that you earned. You protected the $50,000, but you are not able to protect the income. So if you need a nursing home, that income is going to be used to pay for your nursing care. Now, in my example, $10, who cares, right? But if you've got assets of any caliber and you want to start protecting them, then you could be having income streams of, I had a client just last week, $80,000 was their income from, they did very well from their investments, right? So the assets and income split up and they are protected in different ways. So what is the benefit of this? It's more costly, right? So that's not a benefit. It can still hold your assets. That's neutral. The benefit about this is that you retain the right until the day you die to change who the beneficiaries are of this trust. You can also change who the trustee of this trust is. So if you told your children you wanted to make sure that, you were, that you go to this very nice nursing home and that you're doing all of this stuff and that they didn't get you to the right nursing home, you have the right to retain as the grantor the right to change who these trustees are to have who you wish them to be, but they just can't be you. You also have the right to say, you know what? I left this 50-50 to both of my children. But if one of my children predeceased, I was going to pass it to maybe my daughter-in-law. But if my daughter-in-law predeceased, I wanted it to go to her children. So you now have a deceased child. Maybe you decide you don't really want it to go. You want it to stay in the bloodline. You want it to bypass the outlaw and go to your grandchildren. You retain the right to change that through an exception through the Medicaid Mass Health program that says, as long as you change who the beneficiaries are of your trust through your will of all things, it's called a testamentary trust. You can change who the beneficiaries are of this trust through your will up until the day you die. So people like this because it gives control. The other thing is that if you don't get through the 5-year look back period, you can have your trustee bust the trust open, and then everything in it, the 5-year look back period dissolves, right? But you could say, you know what, I decided I don't want to go into a nursing home. I don't want to rely on the government to pay. I want to privately pay at an assisted living facility. And I'm going to take my chances that I'm going to last long enough and my money is going to last long enough with me. So if you had given this same money to your children, and after 3 years, you're like, oh, daughter one, I know I gave you that money, but I need it back. It changed my mind. Again, it depends upon what your family dynamics are, right? Whether that's going to work for you or not. So the two options, outright gifting versus doing Medicaid asset protection irrevocable trust, where you retain some control. There's another tax advantage to a lot of this, and that you really should talk to a CPA or financial advisor about this, mainly a CPA, is that when you gift your house, in my example, it was a $200,000 house. I know that's off the charts for Burlington right now. But your $200,000 house, right? You gift it to your children. If you paid $2,000 for your house 70 years ago, they take that gift at whatever you paid for it, plus capital improvements. So if you paid $2,000 for it, you put on a new roof, so now, and you made other improvements, and it's $20,000 is your cost basis in your property now. And you gifted it to your children when it was worth $200,000. Your children take the gift at your basis, which is $20,000. So if your children decide to sell it the next day for $520,000, they are going to incur a capital gain tax on the $500,000 gain. So, and a capital gain tax is associated with your ordinary income levels, if I remember correctly. Again, this is not my forte, and I always default to having a professional involved, CPA, accountant, when it comes to financial decisions. So the benefit with this is that your basis stays with you, because when you retain the right to the income generated off of this asset, the IRS treats this as an incomplete gift. You haven't gifted everything away. So you normally get a step up in basis upon your passing to whatever the value of this asset is the day you die. So in that same example, your children would inherit this asset at $520,000, and they would not pay any capital gain tax if they sold it right after you passed away. So this is one of the main reasons why people like this. It's to start the 5-year look back period, retain some control over the asset. You know, I mean, I have had clients change it, unfortunately, for addiction. that when something enters into the picture and that you don't want an addict child or someone else that might be a beneficiary to really just fall into their addiction further by giving them large sums of money upon your passing, so that you have the ability to change that. You have your ability to say, I don't want my, my addict child or my mental illness child to get it outright. I'm going to say in my will to create a supplemental needs trust for that child, and maybe have one of your other children be in charge of the money for that child to keep your child safe, but still keep them with some money. So if you're not ready to give up control and divest yourself of the assets, what do? Well, you just have to be prepared to pay for your own nursing home care. And a lot of people do decide that, and that's okay. So I did mention the value of $2,000 earlier, that's the Medicaid limit, the Mass Health limit. That's for a single person. If you're a couple and two of you are alive and you're married, you have to be married, you're up to about $140,000 that the two of you can have. But everything over that amount is going to be used to privately pay for your nursing home care or your in-home care. I talked about the frail elder waiver, which is another type of care, but not in a nursing home, but in the home environment. There are some limitations to that. You cannot earn or bring in more than $2,523 a month to get home care. So if you have your Social Security, your pensions, retirement money, and you're over that limit and you need skilled nursing care, you have to go to a facility if you want the government to pay for it. There is some new legislation that's being introduced in Congress that the National Academy of Elder Law Attorneys is trying to be a proponent to say it's discriminatory. Why do I have restrictions? You're going to pay in a facility, but you're not going to pay at home because I have more income coming in. So that's just something coming down the pike that maybe we're going to see changes there. The last thing to really wrap up is to just say that how to protect your assets, you need to divest yourself of them, whether it's through a gifting program or whether it's through an irrevocable trust. If you need guidance on any of them, we have some appointments that have been set aside for next week that if you'd like to meet with us, we're offering discounted rates to anyone that responds to this. For anyone at home, you'd need to tell us that you were part of this to get the discounted rates for whether you want to do an irrevocable trust to start that, whether you want us to look at your assets and give you a sense of, should you start the 5-year look back period on some of this? The other thing I want to tell you is I never start the 5-year look back period on all of it. I always want my people to have cash. I want you to have flexibility. I want you to keep money so that you can live the life that you want to live and that you have money accessible for you to do the things that you want to do. And then we just start protecting the amount of money you want to protect to leave a legacy for your family or your friends or your favorite attorney. So let me just take a quick look. As I said, we have some special pricing. You need more information. We normally, my rate is normally $350 an hour to counsel you on this type of planning. We're offering a reduced rate for $290 an hour, which is my reduced counsel on aging rate here. In addition, we do have that'll start up this month for 4 more appointments. And then again in September, I do 30-minute free consultations. I will tell you, this is very hard to go over in 30 minutes if you're asking me to review your plan. So you're better off booking an hour and getting the full-fledged consultation, and we can go over a little bit in time if you need that to be done. So If you're not ready to do any planning, and you're never going to want to divest yourself of your assets, I at least ask you to consider even a revocable trust or do something to avoid probate. Probate is what happens when you have a will or don't, when you die, and your assets are held in your individual name, and you didn't name a beneficiary, and you never said who should get what. So if you have a will, the probate court takes the will and they guide you through that process. If you have a trust and you fund your trust with your house, your stock portfolio, you put savings bonds in there, you convert them, you put your personal property in there. Everything in this trust bucket will avoid probate so that a week after you pass away, you don't involve the court at all. And whoever you've named as the trustee of this trust just steps up and says, okay, this is what mom or dad or both wanted to be done. It's all in the trust. We get a new tax ID number for this trust, and we just distribute the assets without involving the court. If we have to go to the probate court, you're looking at 1 year minimum, because creditors have a right to make a claim on your estate for up to 1 year. And then after that, all the assets that are left, your debts are paid, your assets are corralled together, and then your personal representative, it used to be called executor or executrix, it's now called personal representative. They are then in charge of distributing the assets to the named beneficiaries in your will, and then the probate court closes probate after 1 year. But that process is normally running you with average assets anywhere between $5,000 and $15,000. But it takes 1 year. So if you're not going to gift, you're not going to divest, you should at least try to either add people's names to your accounts to avoid probate. There's problems with that too, though, and tax ramifications to that. But do what you can to try to avoid probate. So let's see. Marie, do you think I got everything? Think so. So I'm just going to open it up to take some questions. If anybody has one, and I'll repeat them for the people at home. Yes, sir.
If I have $100,000 in the run now, then government kick in to pay something.
The question is, if he gets his assets down to $2,000, will the government kick in and pay his nursing home bill? Yes. If you are medically eligible and financially eligible. I have a client this year that she was financially eligible, but that she needed help. But the help she needed didn't rise to the level of a skilled nursing facility. So they would not approve her for Mass Health to come in. She had the less than $2,000, but she was not medically eligible. Yes.
Whereas,
Yeah.
the trustee at any time they choose.
The question is, on an irrevocable trust, can a trustee have access to withdraw the money in the irrevocable trust at their choosing?
Or division if they were.
Or divide it, give it to some of the other beneficiaries. So it depends upon how the trust is written. And I write trust different depending upon what my client wants to happen. There are some trusts that have a backdoor clause in them that say, if I'm the donor, the grantor, I'm not the trustee, but I tell the person who is the trustee, maybe my daughter, listen, I know I can't be trustee. I'm going to have you be trustee. And in my trust, I'm going to give you the right to withdraw money out of this trust at any time. So you can do that, but you're going to run into two problems with that. One, if you don't get through the 5-year look back period and you need to bust the trust to now pay for your care, then if your children have taken money out of it, you now need to get that money back. You have to get it back because it would be called a disqualifying transfer. Any money that you give for anything less than its true value, called fair market value, you have a house worth $500,000, you give it to a child for $100,000. Mass Health will say, you just gifted away $400,000. After you privately pay for $400,000 worth of care, then we'll kick in and pick up your tab. But back to your question. So if your children took money out, if the trustee was allowed to take money out and distribute to themselves or beneficiaries, then they have to put the money back if you now need to go to a nursing home. Or some people, if they've gotten through 3 of the 5 years, they say, you know what? I only need like 150,000 to get through those last 2 years to protect a $500,000 asset. Some people do that. They'll privately pay for 2 years, get through the rest of the 5-year look back period, and then 5 years and 1 day, they apply for the government to pick up the tab, and they can then answer honestly, have you given away assets in the last 5 years? No. So I have many clients that come to me and, you know, they're so focused on the 5-year or getting like, sometimes you might have to spend a little money, spend 150,000 to protect $500,000. So the other thing on that is that if you don't get through the 5-year look back period, you have to do something, right, to privately pay. If you give the kids the money, then they are going to have to cure the transfer is what it's called. The other thing is that Mass Health in the past year is examining trusts like they have never done before. And they do not like to see trusts that have this backdoor clause in it. So they are looking for these things. So they could decide that they're not going to approve you because your trust has that clause in it. So Mass Health is a moving target. Every time I come to you, I could come to you with a new thing that they're trying. Their goal is to not pay for long-term care. Our societal system was not designed to pay for long-term care. We had those nuclear families, right? Intergenerational. Everybody took care of everybody else. We have a global society now that's not geared toward that. So the government is now trying to figure out ways of how to take care of an aging population when the children that historically have been there to do that are no longer there to do that. Yes.
Once again, to change the look back to 7.
The question is the government looking to change the 5-year look back period to the 7-year look back period, which almost got through in 2020? And would you be grandfathered in if you have done your planning now? So I think that they will at some point be successful. They are constantly trying. And the reason why it went to 7 years with a hope and a prayer was because they tried 10 years earlier to get it to 10 years and were unsuccessful. So before a couple of years ago, with the change on them attaching life estates, I would have told you that you would likely be grandfathered in, but they did not grandfather in anybody with life estates this time. So I don't see this grandfather clause going to be, I mean, it really depends upon who our legislatures are at the time, if they've done long-term care planning, how do they understand the process? And I mean, we're always looking for money. The government's always looking for money. So, I mean, I know what I probably need. Let's see. Oh, I need a crystal ball. Let me see, will they grandfather us in or not? It's anybody's guess. Life estate still works with the 5 years if they didn't have you sign that form that says they can attach it, because they would normally attach it now. They would do something now when you're first going in, because if you have the life estate in place already, you didn't sign that they can do an attachment, then the property automatically passes to your children or whomever you named by operation of law upon your death. So where does Mass Health go in to say, hey, kids, that's some of ours, right? They do that through the lien process. But Mass Health could maybe try to go to the legislature and say, listen, we need a way to get these automatic liens on. If that the value of your life estate would probably be determined on the day you went into the nursing home, and they would figure out, this is your age, this is the value of the house, your value of the house under the Social Security annuity table or life table is worth 38% of your $500,000 house. And that they would then lien your house for that amount, so that whenever the house is sold, they will be made whole with that 38% value of the $500,000 house.
Happy to.
After what? Whenever the house is sold. Yep, whenever the house is sold. Yes, I'll be with you in one.
Like this, and once you go, they take money.
Could you ask that question again?
Trust on him,
In the just a regular, okay, yeah.
but before that, I go nothing. They take the money from that trust, and after I die, they get.
No, it's a very good question. The gentleman is asking, when do they come and take the money? So if he has maybe a revocable trust that he doesn't have his name on this, but his kids' names are on this, right?
Yeah.
This is not your trust, this is your children's trust, right? And he transferred his house into this trust, right? That's what you're saying? You transferred the house, so in fact, really, you gifted, right? You gifted your house to your children. Here it is. So your children's trust, your house, you gifted your house into their trust, and now in 2 years, you need a nursing home. Your house, say, was valued at $500,000. And when you do your Mass Health application, one of the questions is, have you transferred any real estate in the last 5 years out of your name? You would have to answer yes. And they would say, you better go get that, or we're not going to even take you into our nursing home. Or you need to get that house back, sell it, then you'll have money to privately pay for your care. And then after you've blown through $500,000, then you have less than $2,000. We'll be happy to pay for your care. Yes. A bank account, say? Okay, so if you added you and I, you're going to add me onto your house.
Yeah.
So legally, your obligation is that when there is joint owners of property, the legal terminology is that you both own a 100% interest in the property. So for me to tell you the answer to a tax question, that's more of an arrangement question, right? Like, what do you want to do with the joint owner? Do you want to make somebody responsible for paying the tax bill, somebody else responsible for paying the maintenance costs of it? Legally, I don't know if I can really answer that question because you're each a 100% interest holder in it. So you each have the responsibility to make sure the taxes are paid. How you want to divide that up? I mean, maybe that's a question for a real estate attorney. The question is, if you have a bank account and you add someone to the bank account, is that considered a jointly held asset so that maybe only 50% of the money in the account would be viewed as yours when you're applying for a nursing home? The entire amount is viewed as yours. It is a rebuttable presumption that it is yours is the legal benchmark for that analysis with Mass Health. So you have to rebut the presumption in a hearing that shows this is not all my money. You can see I have this bank account with my daughter, and some of this money is her paychecks going in here. Some of it she took out to go on a vacation. She pays some of her bills out of this. This is my check going in there. These are my bills coming out of there. You would have to be able to show the ebb and flow of money in and out of that account to show that it truly is a jointly held account, to rebut the presumption that it's all yours. Is there another? Yes, sir. The question is, can you put IRA or any retirement money into an irrevocable trust? So any transfer of retirement accounts, IRAs, 401ks, 403bs, CDs, retirement annuities, pensions. First of all, some of them are not assets. They're income streams. Remember we started, one is an asset, one's an income. So you could have, oftentimes 401ks are assets. But oftentimes pensions from companies that they give you a set amount every month. If you said, listen, I want it all GE. Give me the mother load. Give me the whole 400,000 now. They'd be like, no, sorry, that's not the way pensions work, or that's not the way your pension works. You get an income stream, and that's it. There's not even a death benefit sometimes on pensions, right? It's for you. Maybe you took a smaller amount of your pension up front so your surviving spouse would keep some money too upon your death. But then after that, there is no lump sum left to give to somebody. But let's use the example of a 401k because that is an asset. You can transfer it out of the retirement mode, the qualified money mode, out of a 401k status, but it's going to be a taxable event because this is in your name, right? Even right now, when you get a distribution on an IRA, a 401k, a CD that's retirement money, they're very happy to send you a 1099, right? At the end of the year that you have to claim that money on your taxes, investment money or dividend. So it's qualified money. You didn't pay taxes going in. You've got to pay taxes with the money coming out. So if you're paying money on taxes coming out, you can't put it in this state into this irrevocable trust because these retirement assets are individual retirement assets. This trust does not, it's not you. This is not an individual. It also has its own tax identification number. Doesn't even use your social security number. So you would have to, in order to start protecting this money, you have to convert it to, this is called qualified money. You have to convert it to non-qualified money, which means you are going to get a tax on the money when you pull it out to then start protecting it. I have some clients that, many of you probably get RMDs, required minimum distributions, from your investments every year. And without being a professional in this area, it ends up being, I think, about 4% of your investment portfolio every year. So some clients, they want to start this protection, the asset protection, in the 5 years, right? They want to start that. So what they do is that instead of taking out just the required minimum distribution of the 4%, and then they still have, 1, 2, 300,000, they figure out what tax bracket they're in. They say, you know what? I can pull out $30,000 more in income this year, pay taxes at the same percentage, the same bracket, and then I can start protecting it. Or I can maybe put it in just more liquid. And the reason being is that this is what I see is a problem for asset protection strategies for nursing home. Most people have has most of their wealth in these retirement accounts. So you have to privately pay for your nursing home care in Massachusetts with your retirement money. So if a nursing home is running, say you've got income coming in and you still then need to pull $150,000 a year to pay for your $15,000 a month nursing home, you end up having to pull out $150,000 a year out of your retirement money. You're definitely going into a new tax bracket, right? So that's why some clients try to systematically pull it out and say, I'm going to max out my tax bracket. I'm going to start to get it out of the qualified money status. I'm going to then maybe either put it into and start protecting it here. A lot of clients take it from, an investment house, IRA, take it to max out their tax bracket. Now they've got another $30,000 on top of their RMD that they pulled out of, say, $12,000. Go to the same investment house. Do the same exact investments it was in over here, but here it's liquid. So you've systematically incurred the tax burden. You're not going to get this catastrophic 150 grand this year, 150 grand next year, right? So some people do that. I will tell you, you will never speak to a financial advisor that will ever tell you to do what I'm telling you to do. So this is not financial advice. I'm not qualified to give you financial advice. I'm only here to tell you how my clients have systematically used their accounts, especially when they see something like an MS diagnosis or an ALS diagnosis or a Parkinson's diagnosis, that they know they're getting in on the ground floor and that they want to start doing some planning because they know they're going to start using some assets 4, 5, 6, 7, 10 years down the line, if they're lucky. So it's a very good question when it comes to retirement assets. Any other questions? Well, I've had a ball. Oh, yes. So the question is, how does a will become public? So over here is the irrevocable trust that I've been talking about. And I put 5 other documents there. One is a will, the other is a durable power of attorney, and then there's 3 healthcare documents: a healthcare proxy, a HIPAA, and an advance directive. And you can add a revocable trust, the clear one, right, the see-through one, to this as your cornerstone planning. And by the way, I think it's on September 13th of this year, I'll be doing another lunch and learn here at the Council on Aging that I will be reviewing the cornerstone estate planning documents and how to do trust planning with your estate. So one of those documents is a will. So if we have a will, maybe I have one floating around here, not handy. So let's say that this is your will. And you say that this is my executrix or my personal representative, and these are the people that I want to get the assets upon my death. Well, if you have assets that only have your name on them, the only way to get the bank or the registry of deeds to give those assets to the people that you have named on your will is to take this to the probate court and put it into the public record. So you take your will, or you won't. Someone will take your will upon your death if they have to, if you have probate assets. So if you have a bank account that's only in your name, you didn't name a beneficiary, it wasn't jointly held with somebody else, your name alone. When you go to the bank, or when your child goes to the bank and say, hey, listen, my mom passed away and here's her will, and it says that I'm the beneficiary of it. I'm here to close out the account and cash it out and take it. The bank will not give you that money because they don't know if this will was properly executed. They don't know if you were under any duress by a child who was trying to get all the money. They don't know if it was properly signed in front of two witnesses and a notary. So there's very strict formalities that need to be complete when you are creating this whole plan. So that's why the bank says, don't come to me and with your will, you go to the probate court with your will, and the probate court processes it. And they look, oh, did she sign it? Were there two witnesses? You know, is there something here that says she wasn't under any duress or undue influence? You know, okay, this looks good. We will give the personal representative of her will, who she put down here, the right, a letter of authority to go to the bank and then pull out the money. So it's a process. And so that is how a will becomes public. So again, this trust, private. Yes.
Side that we put
A child.
that,
That's right. So the question is that they have 3 children. One child is on a bank account. And then upon the last of them to die, that child then has the right to go and do whatever they want with that money. In a get along, go along household, that's great, right? So if you want, legally, I should say, unless your will says otherwise, and you can tell the banks this, when you go to add a child on, you're adding them on for convenience only. They don't have ownership of it, but for convenience. Your will can say any bank accounts, or your trust could say any bank accounts that have my name on it when I die are, and even if it has another child's name on it, it is for convenience only, that those assets do not belong 100% to that one child, to the detriment of those 2 other children. Right. Yes, if a child is on the title of the account with you right now, as I said, jointly titled assets, you are a 100% owner of it all. That means a child can go and empty out a bank account if they're on the title with you. There is a substitution that some clients use for that, and that is for, it's called a payable on death or transfer on death designation on the account. And it says, while we're alive, we are the only ones that have authority on this account. Upon our death, it automatically passes to this one child, two child, three child. But the better way for that really would be, if you're not going to do asset protection, create a trust, put a revocable trust, put your assets into this trust. You name that child that you want to be in charge of everything as the trustee upon the last of you to die. And then you have a beneficiary designation statement that says, upon the last of us to die, all the assets are equally divided, or this bank account goes to this person, that one goes to that person. So this is much safer. There's also a lot more planning. All of these trusts have special language in them that says if one of the beneficiaries is injured and becomes a special needs person and they have qualified for public benefits, we got them down to below 2,000, right? Now they are in a nursing home on Mass Health, and you don't change your estate plan, and that child gets money. You, in essence, have just kicked that child off of Mass Health. Now they have to use all that money that they got in that inheritance to privately pay at $15,000 a month. So you're going to want to make sure that your trust, both of these, have language that says, if one of the beneficiaries is a special needs person when I die and they get these assets, make sure that you create a special needs trust for them to not disturb their public benefits. Okay, well, thank you very much. Appreciate it. And you can see Marie or Jen, and if you'd like another appointment to kind of discuss this more fully, we can do that at the discounted rates. Your pricing sheets are in there if you would like to take advantage of doing an irrevocable trust, or if you want any of the regular planning, we can do that for you as well.